Are you actually a professor, or is it just Miss Gilchrist? I want to address you properly.
Hi, it's Ms. Gilchrist.
Okay.
Thank you.
Ms. Gilchrist, thanks. Thanks for coming on the show. I appreciate it. So what you actually wrote is you wrote that Gorsuch, like Antonin Scalia, is a proponent of originalism, which means he believes a judge should attempt to interpret the words of the Constitution as they were understood at the time they were written. When the Constitution was written, women couldn't own property. In 1787, women didn't have the right to vote. It would be 133 years before women won that fight, a fight they fought for 72 years. Considering women had no rights when the Constitution was written and there was no mention of women in the Constitution, originalism is sexist. So let me ask you first to expand on that. Is it the Constitution that's sexist or originalism that's sexist, or both?
Well, actually, the original Constitution is sexist, and then the originalist perspective that actually looks to the original document is also sexist. And so we know that when a judge practices originalism, they look backwards. They don't try to see the Constitution in the current context of society. And so by looking backwards, as I said in my piece, at the time the Constitution was written, women didn't have any rights. We were property. So, yes, the originalist perspective is sexist. And so I think Neil Gorsuch will not be good for women on the Supreme Court.
Okay, so two quick things. One, you're right, that obviously, the women did not have rights under the Constitution in many ways. The idea that they were property is an overstatement. They couldn't be sold into slavery. I mean, black people were property. Women were not property under the Constitution of the United States. But I do have a basic question here, which is, what do you think a judge's job is? Right? I mean, a judge, from where I sit, and according to the structure of the Constitution, his job is to interpret the law as it's written, not to make up what he wishes the law were. That's what we have legislatures for. That's why we have people who vote on things. The idea that you're going to have some sort of super legislature made up of the great wise men or women who decide what a text means that has nothing to do with the original meaning of the Constitution. What do you think a judge's job should be?
Well, so what an originalist actually does, though, is goes even beyond that interpretation to an originalist thinks that the 14th Amendment, which would actually give women equal protection, based on what we know from Justice Scalia, he didn't actually think that that protected women. And so he thinks that equal protection does not prohibit discrimination on the basis of sex. An originalist like Scalia also feels that the right to privacy is not included in the Constitution. And so I understand what a judge's job is, but then we also have, thankfully, the legislature. And so the legislature can pass public policies that will give women rights. And
Scalia, to be fair, that's what Scalia says. I mean, that's what Robert Bork says. That's what Justice Thomas says. I'm an originalist. This is what originalists say. We say this is why we have legislatures. The purpose of a legislature is to pass things like the Civil Rights Act of 1964. You don't have judges who just sit there and then pass legislation. This is why we have separate branches. So again, I ask you, you're upset at the outcome of some of what the judges say because the judges are reading the text according to what texts mean. I mean, it's not poetry. But what do you think a judge should do that is distinct from what a legislature does?
Well, to answer that, I mean, what now is happening is so the legislature passes a policy to give women greater access. Let's use Hobby Lobby, since that's a case that Neil Gorsuch, ruled on. The Congress passed healthcare reform to allow women to have greater access to birth control. And when that then went through the court process, because conservatives argued against that, when it went through the court process, it was ruled down. And so, we might have the legislature, yes, we have judges, but with an originalist perspective, like Neil Gorsuch's and like Scalia's, when we try to progress women through public policy, it then is still being shot down in the courts because that originalist perspective, as I mentioned, is a sexist perspective. Okay, so again, the problem is that, take Hobby Lobby as an example. It wasn't that Neil Gorsuch is against contraception, presumably. His church apparently is pro-contraception. The idea that Neil Gorsuch has a personal view that's anti-contraception, that's not accurate. Neil Gorsuch's view is that there's a First Amendment to the Constitution which protects the freedom of religion of people like the religious owners of Hobby Lobby, and said that they don't have to violate their own religion in the provision of health care. Now, you may disagree with that policy. That's why we have an amendment process. So the Constitution does basically enshrine certain fundamental rights. If we disagree with those fundamental rights, there's an amendment process. Or do you think that we should just get rid of the Constitution completely? Because it seems to me that's sort of what you want. We shouldn't have judges. We shouldn't have judicial review. We shouldn't have a Constitution. We should just have a legislature that does all the things that you want them to do, or judges that just say the legislature can do all those things. No, not at all. We need to pass public policies, or we could amend the Constitution. And women did try that through the Equal Rights Amendment, but that too didn't make it through.
Right.
And so, to your point about Hobby Lobby, it is the first decision where two competing interests, the religious freedom, religious rights of individuals, did actually then trump the rights of those who need access to birth control. And so I think a different judge in that position who doesn't have an originalist perspective like Neil Gorsuch's wouldn't have ruled in that way.
So how should a judge read a text? Should a judge just decide what the judge wants to be the law and then just say this is the law? Like, what standard do you use?
So my standard is that with the Constitution, I think it was supposed to be a document, a guiding document. And so I don't think anyone at the time the Constitution was written thought that the world would always exist as it was. And so I certainly think we need that text, but we should interpret it in light of what is happening in present day. We've changed a lot as a culture and as a society. And so to assume that you can use a text from hundreds of years ago to decide cases today just seems ridiculous.
Except that we do that with texts literally every day in the courts. We use the Sherman Antitrust Act to rule on antitrust. We use the Food and Drug Administration Act to determine what the FDA is allowed to regulate. Legislation is designed to be interpreted as text. You know, this is just basic legal 101. I mean, you're supposed to read a text as it's written, not as a piece of T.S. Eliot.
Yes, but we use that text to interpret current day problems. And it seems that when it comes to women's rights, originalist perspective tends to side on the air of always looking backward and not looking at current day because if I wrote a piece of legislation 10 years ago and I said to you, okay, you and I write a piece of legislation today, right? And we use the language of today. We mean something by that language. In this conversation, somebody will read this 100 years from now and we will have meant what we're saying to each other. We understand what we're saying. If somebody wants to read what we're talking about today, and then it turns out that all the words that we're using now mean the reverse because things have changed. Did our conversation mean the reverse of what it meant, or does it mean what we're talking about right now? Words have meaning at the time they are said, and to try and read new meanings into old words just because, quote-unquote, times have changed, you can end up with some really bizarre results. I mean, and the problem here is that, you know, you may not like what Neil Gorsuch is trying to do, but at least it's a rule of interpretation. In the constitutional structure, what we've had is the Supreme Court very often reversing itself on the exact same language by using the sort of rules that you want. So, for example, in Plessy versus Ferguson, you had the Supreme Court say that the 14th Amendment did not apply to black people insofar as segregation was okay. And then 50 years after that, they say, no, it turns out the 14th Amendment actually meant that segregation is not okay anymore. Well, that's silly. I mean, it either meant one or it meant the other. It didn't mean two different things at the same time. One of those decisions is wrong and one of those decisions is right. That's true for every judicial decision. The idea that we can just look to our hearts to determine what a text meant 200 years ago is silly when we can find out what they meant 200 years ago by reading what they're talking about now. And yes, I wouldn't disagree. Where you made the point, though, that our conversation we're having today, what we're saying to one another is what we're saying to one another. And if looked at 100 years from now, it would still mean the same thing. But people using our conversation 100 years from now would have to apply it to that current day because it's not going to look the same. And so we do need to look back at texts, but we need to interpret them with the current climate. And so to say that, I mean, Justice Scalia came out and said that the 14th Amendment does not prohibit discrimination on the basis of sex. Justice Scalia came out and said that there is no right to privacy in the Constitution.
Right, because there aren't any of those things in the Constitution. If you want to establish one, you create an amendment. There's no right to abortion in the Constitution.
The right to privacy is not the right to have an abortion. The right to privacy also covers the right to access birth control. And so that...
Yes, Griswold versus Connecticut, 1965. I'm well aware of the case. But the idea that the founders, the people who wrote the Constitution, were deeply concerned with access to birth control in the federal Constitution is just silly. This is why we have legislatures. The point is that I'm in favor of availability of contraception. This is why I would elect people who would be in favor of availability of contraception. If you just want the courts to do what you want them to do, why not just appoint a couple of oligarchs? We can have Ruth Bader Ginsburg be our queen, and then we don't actually have to have a legislature anymore. We can skip all these expensive election things. Donald Trump wouldn't be president, and the notorious RBG would just rule us all.
The problem for women in this country is that when we pass public policies to increase our rights, they are then shot down by the court, who doesn't believe what you just explained, that we don't have a right to privacy or that we don't have equal protection under the law. And so I don't want to.
That's not accurate. There are dozens of states that had already legalized abortion in large part before Roe v. Wade, and the courts had never struck that down on any grounds. I mean, now you're reversing it. I mean, the fact is that if a state legislature passes a law that makes availability of contraception a thing, that's still not the same thing as, for example, Hobby Lobby, where you're actually forcing people to pay for your contraception in violation of their religious obligations. So if you're just talking about access to health care, then a state is perfectly capable of passing whatever law that it wants, and the courts won't strike it down. There are countervailing interests in some of these cases under the Constitution, and that's what the Supreme Court is talking about in an originalist jurisprudence. But if you want to pass a constitutional amendment, go for it. Again, I guess my final question is this, and I unfortunately have to let you go because it's an interesting conversation, but my final question is this. Why bother having elections? Why bother having legislatures? Why do you, if the American people are constantly doing things that are stupid, or if the American people are constantly electing legislatures that are terrible, and if we can just have judges who are going to be able to apply the Constitution as you see fit, again, I ask, why not just appoint Ruth Bader Ginsburg, the actual Queen of the United States, and she can rule from above, and she'll do all the things you want? And why isn't that okay with you? I mean, tyranny with someone who you agree with seems okay with you a little bit.
Tyranny is never good, and right now I feel as though we're under a tyranny.
Why? What is it? Again, I'm not a Trump fan, but I'm just wondering what he's done exactly. But we can get into that in a bit. That
would be another conversation for another time. No, I certainly think checks and balances are what we need in this country. I'd end by saying what we haven't tried in this country is equal representation. And so maybe when we get a legislative body that is equally men and women, and we get a Supreme Court that's equally men and women, we might see.
What about when we have an electorate that's 54% women? At that point, can we say that we have equal representation because most people who vote are women?
Nope, not yet.
Why not? What happened to the women? Are they all slaves?
Well, we might have equal voting, but we do not have equal representation in any of our bodies of government. And so until we have that, I think we'll see a big difference in the policies and the rights we have as women in this country.
So a woman is not really a female voter if she elects a man? I'm confused again by
No, not at all. I just think that, to your point of should we have just a judicial branch ruling all,